The usual rule is that someone who is applying for permission to stay in this country must not have recourse to public funds, that is to say, must not apply for benefits from the government. And if they do, then they will not get permission to stay. So an applicant who has been in this country illegally or is an overstayer but has a British child or a child who has been in this country for over 7 years, but someone who has no job or has a very low paid job and can hardly afford to feed themselves and their child, but has been given permission to stay in this country and work, but is unable to work because of the child, is not entitled to public funds unless they are absolutely destitute, that is to say, probably have no roof over their heads, probably about to beg, probably starving. I mean, destitute is a very powerful word. Another aspect of the Home Office unreasonableness is charging astronomical fees before an application is made. For example, the fee for the National Health Service, which must be paid for before an application is made, is now for one person £1,000 for an extension of stay of 2.5 years, even if that individual decides not to use the National Health Service. And the Home Office fee for making the application is £1,033. So an applicant, before even thinking of lawyers' fees, has already spent over £2,000 on outgoing fees. It's very difficult. And that is for one person. Imagine how much it would be for a family of 3 or 4 before lawyers' fees are considered. These are draconian measures taken by the Home Office and unfair. But there have been 2 decided cases, one in the High Court and one in the Upper Tribunal, dealing with no recourse to public funds and also remission of fees. And both cases say that it is not necessary to be destitute in order to obtain public funds or to obtain a remission on Home Office fees. I have prepared an article on these aspects of Home Office policy, which I hope you will enjoy reading. Thank you.